Welcome. Finally, new labor laws are implemented, something for which people have been waiting for a long period of time. We have been waiting for the new era because the erstwhile labor laws were very bureaucratic, very cumbersome, and they were not able to give either wellness to the employees or to the employers. They were benefiting only the inspectors. There were so many inspectors, so many compliances, and the only purpose of these inspectors was corruption. We had a very widespread corruption in India, and everybody knew about it. Now, we have seen transformation of many departments in India. Let us see similar transformation should also take place now in the labor department. I'll give you the example of income tax. In India, once upon a time, almost everyone in income tax department was corrupt. Corruption was so high. Every employee in income tax department was corrupt. Bribery was very common in income tax department. Almost every income tax officer was taking regular bribes from their network, and everybody knew about it. And then came a change. Income tax procedures and these things were converted into online procedures. And thereafter, it was complete transformation. And today, we must appreciate and acknowledge that income tax department is one of the best departments in terms of governance. Corruption has almost reduced to zero, and there is very high transparency, and everybody feels pride that they are working in a very uh, responsible department, and citizens are given due care, due attention, and I mean, no possibility of any favoritism or any uh, personal, uh, something unfairness. So, can we have similar thing among the labor department? This is possible, and for this, the government has introduced transformative four new labor codes. They have been implemented from 21st November 2026 25, and now they are in operation. And let us have a brief look at them. So we'll look at the four codes: Code of Wages 2019, Code of Industrial Relations, Code of Social Security, and Occupational Safety Health Code of 2020. They have all been implemented on same day, 21st November 2025. Indian labor laws framework has been complex over time, creating significant compliance burden through multiple registration licenses, returns, evolving work patterns, new forms of employment underscored the need of a simpler and more coherent system, leading the government of India to consolidate and rationalize 29 central labor laws into four labor codes. 29 labor laws have been now replaced by four codes only. And look at the changes. Earlier, there were some 24 registers required under these laws, and now these registers have been the total number of these registers that are required now are earlier there were 84, now they are only 8. Earlier there were some 181 forms, now there are only 73 forms, as you can see. Earlier there were 300 draft rules. Now, sorry, earlier there were 1400 draft rules and 31 returns, and now single electronic return is sufficient in all these four laws. That's a very beautiful aspect, right? And so these are some of the beautiful comparison, as you can see, right? The major changes are in terms of returns, single return, and registers. Total registers are now 8, and forms now you have 73 forms, but they are all digital. I mean, you have to fill online. So these are the things. Code of Wages 2019. Code of Wages 2019 amalgamates four wages and payment related labor laws. It aims to balance the rights of the workers and facilitate ease of compliance for the employers. Code introduces key reforms to streamline and strengthen labor legislation. The code safeguards employees' interest through universal minimum wages, right? Compliances. Employer shall pay minimum rate of wages notified by appropriate government. You see, minimum wages are prescribed by central government as well as state government, and where state government has notified the minimum wages which has to be followed by the employer must not discriminate on the basis of gender in paying wages. Means you cannot pay lower wages to women and higher wages to men as was done earlier. It is not permissible. And every establishment shall fix wage period which may be daily, weekly, fortnightly or monthly. All wages must be paid within prescribed time limit. If it is daily wages, the wages must be paid at the end of the day. If it is weekly wages, then the wages must be paid on the last working day of the week. And if it is fortnightly, then the wages must be paid by the second day after the end of the fortnight. And if it is monthly, then they must be paid before the end of the seventh day. That means if you are paying monthly wages, then before the seventh of the next month, you must pay the before the expiry of the seventh day. Sorry, so you must pay before seventh end. Means you can pay wages up to seventh of the next month, right? Weekly hours are prescribed, and weekly hours and weekly hours are 48. And now there is a provision that if required, you can have 4 day week also. Means employees can work for 4 days and enjoy 3 weekends. That is now possible, but the total weekly hours would remain 48. If workers are asked to work for more than 48 hours, then they will have to pay at the double rate overtime. Because if they are asked to pay more than their prescribed time, then overtime is required, and overtime is double the rate. If the employee whose minimum rate of wages has been fixed under the code works beyond normal hours, then the employee must be paid overtime, and the overtime rate is twice. So like if the normal hourly rate is 200, then overtime rate will be 400 rupees. Registers and records. Employers must maintain following registers in proper prescribed format. Which are the registers? Attendance register, wage register, overtime register, register of fines and deductions. So being HR manager, you must know that these are the registers that you have to mandatorily maintain. These registers must always be kept updated, and they can be maintained either in physical or in electronic form. The record should be preserved for a period of at least 5 years, right? Employers must issue wage slips in prescribed form to all the employees. And on your notice board, you must properly display the minimum rate of wages, the normal working hours, the wage period, the date of payment of wages, the name and address of the inspector cum facilitator. Now, the government under the new wages codes doesn't call them just inspector. They are now called inspector cum facilitator, because their role is not that of inspector. Their role is to facilitate. They are there to get the law implemented. They are not there to collect their bribes as it was done earlier. So earlier, the inspector Raj was there, and we all know factory inspectors and so many inspectors were operating, and they were only busy in collecting, and that's how, because of their improper deeds, the labor law implementation was comparatively poor in India, and we all know about it. Everybody knows about it. Now the change has taken place, dramatic change has taken place, and improvement is already visible, and we are now witnessing a transformation. And soon, probably, just like income tax department has completely transformed, similarly, we would see complete transformation in the field of labor law, and these inspectors will actually work as facilitators. Authorized deductions. Only authorized deductions are allowed under section 18, and employers must make only those deductions which are authorized under the code. And these deductions are for deductions for absence from duty, deductions for damages or loss, deductions from recovery of advance or loan, deduction for fines imposed after giving proper notice and proper permission to be heard. Then house accommodation or amenity charges. Then deductions shall not exceed 50% of the wages. right? If the total wages is 10,000 rupees, you cannot charge more than 5,000 rupees as deductions. And these deductions should be properly documented, written down in the register of deductions. So you have to maintain a fine of registers and deductions, and proper entry must be there. Bonus provisions. Bonus must be paid to every employee who draws wages up to the limit set by the appropriate government and has worked for at least 30 days in the accounting year. So, bonus has to be paid to every employee. Annual bonus is paid minimum at the rate of 8.33% and maximum 20% of the wages earned by the employee. That means every employee will be entitled to get 1 month wages or 1 month salary as bonus, right? Now here bonus is applicable to those employee whose wages or salary is less than the limit prescribed by the government. Bonus here is not available to those people who are getting very high salary. This is the bonus which is meant for as per the law. Earlier there was a law called Payment of Bonus Act 1965, which has now been merged into this law. So earlier under that law, it was mandatory that every company had to pay bonus at the rate of 1 month wages to every employee. And the same has been now incorporated under this law. As you can see, 8.33% bonus, which works out to 1 month salary in a year. Maximum is 20%. So bonus must be paid to every employee now, as per section 26. Now let us understand Industrial Relations Code. Industrial Relation Code 2020 seeks to consolidate, rationalize the provisions related to trade union, conditions of employment, industrial undertaking, and investigation and settlement of industrial dispute. It amalgamates the three central laws into a single code. Earlier, we had the law called Trade Union Act 1926, Industrial Employment Standing Order 1946, and Industrial Disputes Act 1947. These three acts have now been merged into a single law that is called Industrial Relations Code. Now there is a, bipartite committee which was already there in the earlier Industrial Disputes Act, that is called Works Committee. And Works Committee means if you have more than 100 employees, you must appoint a Works Committee. And Works Committee would have equal number of representative from management and workers. They would meet together and they will discuss the day-to-day working issues. They will discuss the way the factory is running on, and then they will prepare the action plans, right? Number of representative workers shall not be less than the number of representative of the employer. The representative of the worker shall be chosen from among the workers of the establishment, should be as per the prescribed by the government. Okay. Then grievance redressal committee. Now GRC is mandatory. Every organization which has 20 or more workers must have one grievance redressal committee, and this grievance redressal committee will have equal number of representative from workers and management, right? The total number of these grievance redressal committee should not be more than 10. So if there are 10 members, 5 would be from management, 5 would be from workers. The chairman would be once from management and once from workers, so it would be alternate, right? For 1 year the chairman is from management, for next year the chairman would be from workers, right? Committee will decide upon the grievances received and will resolve them within 1 month. Committee must ensure adequate representation of women workers, which shall be at least proportionate to this share in the total workforce. Like if there are 20% women in a factory, then in the grievance redressal committee, at least 20% members would be female, right? So this is the provision that is provided in the act. Any worker who is having any grievance, any complaint, can submit the application to the grievance redressal committee, and redressal committee will look into that grievance and prepare and submit its report after 30 within 30 days from the date of receipt of the application. So if the application is received on 1st April, by 30th April they have to resolve the grievance. Standing order. Earlier, standing orders were required if the number of workers was 100. Now this limit has been increased to 300. That means if more than 300 workers or 300 or more workers are working in your factory, you have to prepare a standing order, and the standing order, you may either adopt model standing order. If you want to develop your own standing order, you have to get it prepared, get them approved, and then you have to paste it on the main gate of the factory. Standing orders will prescribe the terms conditions of the employment. They will prescribe the basic rules regulation regarding place of work, the terms timing of the factory, the terms conditions of the work, etc. The employer must consult trade union also, and trade union should also be given a copy of the model standing order. And if trade union has asked for some suggestion, then you can have discussion with them and finally get the proper standing orders. So these standing order, the draft standing orders must be pasted and sent to the trade union representatives, and their suggestions must be incorporated. The certifying officer of the government must certify the standing order within 60 days, failing which the draft standing order would be considered as certified. So within 60 days, the standing orders have to be approved, right? Employer must consult trade union and get the trade standing order draft. So recognition of the trade union or negotiating council. As per law, if a trade union has got 50% or more, 51% or more workers, then that trade union will become the negotiating trade union. It would be recognized trade union. If you do not have any single union like this, then there would be a negotiating council, and all those unions which have 20% or more voters would become part of this negotiating council. They will send their representative in the negotiating council, and this negotiating council will have the power to negotiate in the collective bargaining with the management. So this is a way, you can say, to give recognition to the trade union, to make the trade union part and parcel of the management, to make the trade union participate in the management of the company. Any recognition of the negotiating council will be valid for 3 years from the date of its constitution. This period may be extended by mutual agreement. And if you want to change the terms of condition of service, then you have to give prior notice. At least 21-day notice is required, and then only you can change the service condition. Otherwise, you cannot do it. Now, let us understand layoff, retrenchment, closure. These are prescribed in chapter 9. Every organization which is having more than or equal to 300 workers will not be able to do layoff, retrenchment, closure without government permission, right? Those factories which have between 50 to 300 workers, they can do it, but with proper notice to the government. They can do layoff, they can do retrenchment, they can do closure, but they have to give proper notice to the, they have to serve notice to the government, right? If worker is laid off, he must be paid compensation equal to 50% of the basic wages plus dearness allowance, right? So that means if the worker's wages is 200 rupees, he would be paid, I mean, 100 rupees. I'm just giving example. If a worker's wages is 1000, he will have to be paid 500 rupees. So 50% has to be paid in case of layoff, right? In case of retrenchment, you have to pay at the rate of 15 days average wage for every completed year of service as compensation. For example, a worker whose salary is 10,000 rupees and who has worked for 10 years, then he would be paid 5 months wages. 5 months wages, uh, because 15 days into 10 years. So he would be paid 5 months wages as a retrenchment compensation, right? Employees must give 1 month notice prior to the retrenchment, right? So you must understand difference between layoff, retrenchment, closure. Closure is permanent, forever. Layoff is just temporary. You do not come today, but you have to come tomorrow again, right? If you are not able to give employment to a worker because of situation beyond your control, like there is no power, or there is flood, or there is natural calamity, or there is overstock of the finished goods, something like that, and then you have to lay off. Layoff means do not come today, come tomorrow. So in case of layoff, you have to give 50% wages as compensation. Retrenchment is bye-bye. When you ask a worker that, okay, now you do not come, that is called retrenchment. And then you have to give compensation to the worker. You have to give notice at least 1 month, and then you have to give him retrenchment compensation. And closure is permanent closing of the factory. And retrenchment is done when you are unable to provide the worker any opportunity to work because of some factors like uh, no demand or something like that, which you have to justify. Now, workers reskilling fund has been created, and employer is required to pay at the rate of 15 days wages whenever employee is retrenched. So when you retrench, you have to pay to government workers reskilling fund, and government will use this fund for reskilling the workers so that after retrenchment they are not unemployed, they can find some alternate job. This must be appreciated because this is the responsibility of the government. So industrial companies which are having 300 or more workers, they cannot do layoff, retrenchment or closure without taking government permission. If the worker is laid off, the employer must pay compensation equal to 50% of the basic wages. Employer must give 3 months prior notice before retrenchment in case of these factories. Retrenchment compensation must be paid at the rate of 15 days average wage for each completed year of service. Employer must contribute 15 days of wages per retrenched employee to workers' skilling fund. So this is a beautiful provision now. Now let us discuss mandatory notice. Now closure also. Let us discuss closure also. If an employer is intending to close an establishment, then he must give at least 90-day notice to the government. I mean, not notice. He should take permission from the government, and he has to give the reasons for the closure. And if the government is convinced that yes, closure is the only option, the government may give permission, and the uh, workers have to be paid the compensation. The copy of the notice must also be given to workers representative. Now let's talk about mandatory notice of strike. Strike is done by workers, lockout is done by the employer. And before strike, it is mandatory that the workers representative should give notice of the strike. And the strike should the notice of the strike has to be given to the employer, and employer must give that notice to government within 5 days, so that the government is also aware that it is there. And earlier prior notice was not mandatory, but now it is mandatory, right? So notice has to be served, and both in case of strike or in case of lockout, the proper mandate notice is mandatory. And thereafter there would be meeting. Government may ask conciliation officer to hold a meeting between them, and get them to reach at an agreement, right? So conciliation officer is appointed by the government to look into the industrial dispute, right? Occupational Safety, Health and Working Condition Code 2020. Earlier, there were various laws. 13 laws were there, which have now been consolidated into a single law, Occupational Safety, Health and Working Condition. Primarily, this is focused on ensuring that the factories work with proper, good working conditions for the workers, right? Uh, this has the benefit now. There is a single all India license, and there is now electronic filings, time bound approval. The code ensures safety and health of the workers, and this is binding on factories, on mines, on docks, on plantation construction works, on motor transport, and other establishments wherever 10 or more workers are working. Registration. Every establishment which has 10 or more employees must apply for registration within 60 days of its existence. Applications will be made electronically on the portal prescribed by the government. Establishment already registered under the Act must get themselves registered. Uh, for a registered establishment, the employer must intimate any change in particulars of the employment electronically within 30 days to the registering authority. If employer wants to change, or if the employer wants to close down, or if the employer wants to uh, give some changes, they must give a notice to the government and obtain required permission from the government, and then only they should do it. Safety committee. Every organization, every factory must constitute a safety committee as prescribed by the government. Safety committee will consist of representative of employer and employee both. Every organization which has got 250 or more workers, or mines which have got 100 or more workers, must appoint safety officer, and the safety officer shall possess the prescribed qualification and perform duties as prescribed by the government. Employers are responsible for maintaining safe, healthy, suitable working conditions in the organization, including cleanliness, including hygiene, including proper ventilation, lighting, safe drinking water, separate toilet for gents and ladies, and for transgender workers, adequate space, effective arrangement for waste disposal as prescribed under Section 23. Employers must provide welfare facilities including washing facility, separate bathroom facility for male, female, and transgender workers, sitting arrangement, and locker rooms, and first aid kits, and restroom, and shelter rooms. So they have to provide all these things. Canteen is required if 100 or more workers are working in the factory. So you have to have canteen. Establishment must provide an ambulance room in every mine and building or other construction work wherever more than 500 workers are working. So ambulance room has to be provided. Registers record return. Employers must maintain proper registers. Register of employees, register of attendance, that is called muster roll, register of wages, overtime deductions, overtime register, deduction register, dangerous occupations register. Employers must issue wage slip as per the prescribed format. File Employer must file annual return electronically as prescribed by the government. The register must be maintained electronically as prescribed. Employer must notify the government of any accident that happens in the factory that results in death, or if there is any death or if there is any injury to the worker, then within 48 hours this information must be communicated to the government. If there is any dangerous occurrence taking place in a factory, whether it causes injury or not, employer must notify that to the prescribed to the government in prescribed form within time specified by the government. Right? If any worker faces occupational disease, which is mentioned in the third schedule, then employer must notify to the government within as per the prescribed format within the specified time. Women are allowed to work in all establishment and in all types of work. Women can now work in every establishment in every type of work. Where women are employed between 6 a.m. Uh, 6 a.m. I mean before 6 a.m. means if you are employing women, I mean before sunset or after sunset, means after 7 p.m. Employers must obtain their consent and ensure compliance with the prescribed safety measures, holidays, working hours, and other conditions prescribed by the government. Means if you are employing women in night shift, then you have to take consent of the women and you have to comply with the prescribed guidelines of the government. Employers must provide Adequate safety safeguard prior to employment of women, right? It is prescribed under section 44. Proper health and safety security arrangement has to be done. If it is dangerous occupation, then you should not employ women there, and ensure that there are proper safety. Employment of pregnant women in manufacturing processes or operations involving serious risk of bodily injury, poisoning, or disease should be prohibited. This is prescribed under section 82. Uh, every factory will have to take license. Any factory which is having factory is required to have license, especially for BD worker or other such things. So license is required, and this is applied. Contract labor, whenever you are employing contract labor, then you have to obtain proper registration of them, and the contractor has to have license. The contractor employing 50 or more contract workers must obtain license. The license shall be valid for 5 years. Contractor seeking to provide the contract labor must take permission from the government. Principal employer will be responsible for providing welfare facilities to the workers. If the contractor is not paying wages, the ultimate principal employer will be responsible for this purpose. If in case the contractor fails to make payment of the wages within the prescribed time, then the responsibility will fall on the principal employer. If a factory is employing 10 or more interstate migrant workers, then that factory will have to uh, make special arrangement for that. Uh, they will have to provide a journey allowance. Employer must pay every interstate migrant worker uh, a lump sum journey allowance once in a year to cover to and fro travel between the place of employment and the worker's native place. Uh, Employers who are having mines, then they have special duties with regard to safety of the workplace, because in mines we get many incidents of accidents. So they have to maintain proper safety. They have to ensure that the workers who are working in mine do not face any challenges. Employer must comply with occupational safety and health standards to be notified by mines by the central government. Employer must ensure appointment of welfare officer in every mine where 250 or more workers are working. If you have 250 or more workers, then you have to appoint a welfare officer. Employer must undertake medical examination of workers before uh, periodic intervals as prescribed by the government. So there should be periodic medical examination. Employer must ensure that every mine is under the control of a manager who possesses prescribed qualification. Employer must comply to regulations related to mines notified by central government. Additional provisions for major docks. Employer must comply with occupational safety and health standards specified by docks. Employer must comply to regulations related to major docks. Additional provisions for building and construction workers. Employer must provide free temporary living accommodation to building workers. See, if you are having building construction workers, you have to provide them temporary building so that they can stay there and undertake the construction of the building. Principal employer must make payment of the expenses incurred by the contractor for providing accommodation to these workers. Employer must not employ any person who is known or reasonably believed to have hearing impairment or defective vision or a tendency of giddiness in a building construction work, because then there would be risk to his life. Employer must comply with occupational safety and health standard notified by the central government. Code on Social Security. Social Security was enacted in 2020. It combined 9 labor laws. These 9 labor laws were Employees Compensation Act, Employee State Insurance Act, Employee Provident Fund Act, Employee Exchange Compulsory Notification of Vacancy Act, and Maternity Benefit Act, Payment of Gratuity Act, Senior Workers Welfare Fund Act, and Construction Workers Welfare Act, and Unorganized Workers Social Security Act 2008. So these 13 acts were, sorry, these 9 acts were combined together, and we have created now Social Security Code. So the Social Security Act code is now applicable, and Provident Fund. Every organization which is having 20 or more workers must have Provident Fund. They must contribute to Provident Fund, and Provident Fund is now 10%, means 10% is contribution by workers and 10% is contribution by management. So there are 3 types of schemes of the Provident Fund. Employees Provident Fund scheme, for which the Provident Fund shall be established for the employees. So Provident Fund can be when you can contribute to Central Provident Fund. Both employer and employee can contribute, or you can create a separate fund, right? So that, or you can have employee deposit linked insurance scheme. So employer must contribute 10% of the employee's wages towards Provident Fund. Employees Provident Fund contribution must be equal to employer's contribution. So they are equal now, 10% by employer, 10% by employee. They contribute to Provident Fund. ESI, employee state insurance. Wherever you have 10 or more workers working in a factory, then you have to contribute to ESI. And ESI means taking care of 6 benefits. These 6 benefits are sickness benefit, maternity benefit, disablement benefit, dependence benefit, medical benefit, funeral benefit. Right? These 6 benefits are covered under ESI Act, and the government is establishing ESI hospitals in every city where workers can go there. Gratuity. Gratuity must be paid by the employee on the, completion of the service. Gratuity is paid at the rate of whenever earlier gratuity was payable when 5 years of service was there. Now even if you have completed 1 year of service, you get gratuity. Gratuity is paid at the rate of 15 days of wages per year of work that you have worked. Like you have worked for 10 years, then you are entitled for 5 months gratuity payment, right? Employer shall pay gratuity to fixed term employees on termination of their contract. Gratuity must be paid at the rate of 15 days wages for every completed year of service. That is a general norm. Maternity benefit. Every woman who has worked for 80 years in 80 days in a year is entitled for maternity benefit. Maternity benefit is 26 weeks of leave that should be provided to the employees, and the employees also get 3,500 rupees as medical bonus. Employer must provide 2 nursing breaks also to the women until the child is of 15 months of age, right? And there is a provision of 6 weeks of maternity benefit in case of miscarriage. Now, crash facility is must if 50 or more workers are working. So you have to provide crash. Where children can play, children can enjoy. So crash has to be provided. Employee Compensation Act provides that if a worker faces any death or any occupational disease or any accident, he should be provided compensation. Right? Uh, Gig workers are also covered under the Social Security Code. Gig workers are also able to get. Aggregators are required to contribute between 1 and 2% of their annual turnover, subject to a cap of 5% of the total amount paid or payable to the gig or platform workers. This is the new provision, right? Then building and construction workers, they are also covered under this, and there are provisions for them. The major benefits are that the new wages codes, the new industrial relations code, they have given single definition of the workers, single definition of the employer, and they have simplified the procedure, and they have given very simplistic provisions.